being here today. And it's an appropriate time to thank my two subcommittee chairmen who have done outstanding work this session, Chairman Reeves and Chairman Setzler. We have met just about every day, I believe, every working day of the legislature this committee or subcommittees have. And so I firmly believe we're one of the hardest working committees up here, and that wouldn't be possible without our outstanding members, many of whom are here before you today. So at this point in time, what we'll do is we will go ahead and roll into our agenda. We have some very special guests with us here today. And what maybe we could do is ask Mr. Thompson, would you like to come forward with our special guests? And we have some chairs set up so we can go ahead and begin with testimony. And if you'd like, I'll go ahead and recognize you at the podium so that we can get started.
Chairman, if I could, I'll have Glenn Birch, who's past president for Mothers Against Drunk Driving, to come up, also a Georgia resident. Glenn, if you'd like to come up. Thank you again for the time, Representative Evstration. As you know, an important issue that we're working on this session is ensuring safe, sober driving after a first conviction DUI. And so working with Representative Sands and other members on the committee, we'll have that proposal in front of the committee later this session. So we'll be working on Senate Bill 208. So thank you for all your work on the issue. But if we could have Glenn come up, Glenn's worked on similar issues. 34 states have all offender interlock laws, which requires people convicted of DUIs, even first offense, to serve some time on the interlock device to ensure sober, safe driving. So Glenn can certainly share work that he's championed in other states. He's also a victim, so he has a personal story. So thank you so much.
Yes, sir. Thank you. Thank you, sir.
Good morning.
Good morning.
It's been my pleasure to spend some time with you here today. As you mentioned, I am a former national president of Mothers Against Drunk Driving. I always get the ask, well, where's the mother? Well, believe me, I am a mother. But I am also the first dad and the first minority to be national president. Why? Because the drunk driver doesn't discriminate. I've got a story that I'd like to tell you, and there's information. Believe me, my partner here, Frank, and I both, again, I've got a personal story that I can tell you, and again, he's got the data. But if I could just share a few things with you. My youngest son, Courtney, here's a picture of him. I've got two of my three sons in this picture. And it was Courtney at the age of just 2. It was May 3rd, 1988, when my son was struck by a drunk driver. The car was going over 70 miles per hour. Yeah, I said 70. Speed limit clearly posted, 30 miles per hour. And my son was driven probably about 50 yards before the car came to a stop. Unfortunately, the driver didn't have insurance. The driver had 3 prior convictions. Wouldn't it have been nice if an interlock had been placed on his first offender conviction? And I want to help drive that point to you. So I started volunteering for the organization Mothers Against Drunk Driving, and I will tell you, in my year of 2005 to 2008, it was our 25th anniversary, and Matt came up with a campaign, a bold campaign, and it was a campaign to eliminate drunk driving. Part of that is our mainstay is the alcohol ignition interlock technology. You know, officers have a hard time out there stopping again and again and again. While the drunk driver drives at least 80 times before he comes to a stop on his first conviction. And then again, getting convicted is another different story. So they've had their chance. Unfortunately, my son, Courtney, didn't have another chance. So what my mission is to drive the information, the knowledge, the personal story, mothers, fathers. I give fathers permission to cry now. I can't tell you how many fathers and mothers have told me, thank you, Glenn, for sharing your story, because we all hurt. It's a senseless death. It's 100% preventable. And so that's why after 20 years, I keep coming up and telling my story and hoping that you legislators will understand what I'm saying. Since the campaign began in 2006, we have 34 states that have passed the law for the first conviction on the alcohol ignition interlock. Being a resident of Georgia and Florida, I say that because my mom is from Georgia, my dad's from Florida. We need it in this state. I can't tell you how close I am to my grandchildren, and one of the reasons why is because Courtney is not a part of my life. So what I ask, and all the citizens representing MAD, I'm the face of the victim, and I want you to know that we can save lives in Georgia. Pass this bill. Here's our chance to get it before they get us. It's an aid to law enforcement, and as I mentioned, we've got the technology, we've got the data, and Frank and I will both be available to help you understand that. But if you want to ask anybody, ask a mother, and they'll tell you why it makes a big difference. Thank you for your time.
Well, thank you very much for your testimony and your willingness to be here with us today. I know we heard a good bit of testimony last year, sir. Would you like to come forward again and just brief us on, as the president said, 34 other states have a mandatory interlock for a first DUI offense. Is that right?
Mr. Chairman, that is correct. And again, last year, as you mentioned, Matt spoke in front of this committee twice. And this issue was actually, we're working on the bill, but out of respect of the implied consent ruling from the state Supreme Court, we decided to not actively push it. But since we've last spoke here, 2 states, Kentucky and New Jersey, enacted an all-offender ignition interlock law. And if I can just be real brief,
Please.
Following on Glenn, ignition interlocks are 67% more effective in reducing repeat offenses than license suspension alone, and that's according to the Centers for Disease Control and Prevention right here in Atlanta. And if you pass this legislation that's being worked on as an amendment to Senate Bill 208, it will save 60 lives a year. And that's just looking at Insurance Institute for Highway Safety data that shows that these will reduce drunk driving deaths by 16%. And the third thing I would just like to note is this is MAD's annual Advocacy Day. We're having a press event at 2 o'clock, and we're going to be pushing for this. We've been pushing for this since 2008 here in Georgia actively, and we really hope this is the year it happens. So this isn't a new issue. And just real briefly, if there's concerns about the cost of the device, it costs $3 a day, but under the proposal that's being floated, there is an indigent program that would allow for the device at a reduced rate with the interlock vendors picking up the cost, not others. With that, open up to any questions. Thanks.
Well, thank you. There are a few questions. Representative McLaurin.
Thanks, Mr. Chairman. Thanks for being here. What is the indigency cutoff that's being discussed right now?
I believe, and it's in the language that's being discussed as an amendment to Senate Bill 208 is currently Senate Bill 435, and I believe it's 125% of the federal poverty level, and then there's also a waiving of the installation fee. Now, Matt has always said the cost of the device shouldn't be a reason that a person doesn't utilize the device. And if there's concerns that there should be more robust of a standard so that more people can qualify, we're open to that. Other states do it too, like California and elsewhere.
So you would be open potentially to a different line or a graduated qualification program, like graduated indigency qualification?
Whatever this committee decides, yes, Matt has been open to that. We just don't want it to be a state-run program because state-run programs get rated to balance budgets. At least in other states they do, so it should be on the onus of the vendor to pay for the device. And I also believe under the bill there's actually more regulation of the interlock vendors as well,
Okay.
Which is a good thing.
Okay, thank you.
All right, so I think what you referenced was there's a pending Senate bill in our committee that where a substitute is potentially going to be recommended by the sponsor that would include these conditions. And so I know you mentioned you testified, or Matt testified twice last year. My recollection is we probably had about 6 meetings about following the Elliott opinion, and there was extensive testimony that was heard about this potential proposal that might be coming. Any other questions? All right, hearing none. Thank you so much for being here today. Yeah,
thank you,
thank
Mr.
you very
Chairman.
much. So, All right. Yes, sir. Thank you. You can go ahead.
Good morning. Wanted to say thank you very much, Mr. Chairman, and to the whole committee for the opportunity to come here and speak to you on in favor of all offender interlocks for people convicted of DUI. My name is Dr. Benjamin Nordstrom, and I'm the executive director of the Foundation for Advancing Alcohol Research, or responsibility.org. So we're a national nonprofit that is dedicated to reducing alcohol-related harm in societies with a specific focus on eliminating underage drinking and eliminating drunk driving. We're funded by 8 of the nation's leading distilled spirits producers. So I'm an addiction psychiatrist by training. I've practiced for many years. I'm also a criminologist, and I serve in the U.S. Army Reserves as a psychiatrist. It's actually, I was down here this weekend for a battle assembly over at Fort Gillem. Over my career, I've treated countless people with different substance abuse and mental health related conditions, and a lot of them are DUI offenders. Ignition interlocks really should be mandatory for all DUI offenders. Expanded use of this technology is one of the most effective actions that Georgia could take to stop impaired driving. And as you heard before, 34 other states have already done so. Study after study has proven the effectiveness of this in reducing recidivism and in saving lives, as was just said in the testimony that we just heard. The first DUI really does present an opportunity to change behavior. However, meaningful sanctions have to be put into place in order for that to happen. A survey that we did, my organization did back in 2006 among repeat DUI offenders found that 81% of them would have been more likely to change their behavior if more severe sanctions had been applied on their first arrest. So we know that interlocks work while they're on the vehicle, especially when they're combined with screening and assessment and when necessary, treatment. It's not only a sanction, it's a public safety action, and it benefits everyone who's on Georgia's roadways and sidewalks. The interlock allows for offenders to maintain their jobs, be part of their families, continue to be contributing members of society, while also ensuring that drunk driving can't occur. And that protects not only the safety of the general public, and this is something that's frequently overlooked, it also protects that offender's life. The devices cost around $75 to install and cost about $2 a day. Now, one thing that's important to bear in mind is a lot of people who get arrested and tried for DUI find the resources to retain defense counsel. If they're convicted, they have a lot of fees that are assessed to them. And the ignition interlock should be the most important fee to levy because it's the only one that can save lives, including the offender's own, and protect the public as the impaired driver is prevented from repeating their behavior. So with that, we really encourage you to do everything in your power to support the use of interlocks in all DUI convictions in Georgia. Thank you.
Well, thank you very much. Really appreciate the testimony that was offered here today. I expect we're going to be hearing a good bit more about this, and I don't see any questions, but if any members of the committee have questions, there'll be opportunities either associated with the press events later this afternoon or in individualized meetings. Glenn, I just want to thank you for your courage and being willing to share your story and your leadership to help others, not only in Georgia but throughout the country, to not suffer a devastating loss like you've personally experienced. And that, I think, is what is truly inspiring and inspires lawmakers to want to seek to take action to ensure that that public safety is protected, particularly when we have new technology, which can be of asset to see that through. So thank you, sir. Thank you very much. All right, so we have 2 other bills on the agenda at this point, but we are short of a quorum. So what we'll do is we will just suspend for the moment and see if other members can join us in the room, and then we will be right back. before the Judiciary Non-Civil Committee. And our previous posture was wanting to review potential statute of limitations or statute of repose issue, which I believe has been resolved. Does any member have any comment further about that issue? Well, hearing none, our previous posture was there was a motion and a second. Just to perfect the record here, I'll accept a motion at this point in time. All right, there's a motion on House Bill 1083 LC 289709S substitute. There's a motion and second. All right, any amendments? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed?
No.
All right, we'll see a show of hands on that. All those in favor, please raise your hand. And all opposed? 4-4, chair votes aye, so it passes. All right, next bill is House Bill 43. So Representative Setzler is currently, Representative Setzler has been working on an issue for the past few years concerning maternity supportive housing residents. And members of the committee will remember House Bill 43 sat dormant in the committee because it dealt with a matter that was handled over from the Senate. That was the inappropriate sexual contact with a person in authority, and so now this is it's being used as a vehicle for some other language that deals with the maternity supportive housing residents bill. Sounds good. All right. All right. The second part of the bill deals with reporting to the Education and Youth Committee in the Senate and to the Juvenile Justice Committee in the House of applications by families to become foster parents, and then how many referrals are made to private foster agencies. And part 3 of the bill is cleanup language for the equitable caregiver statute that Chairman Reeves and I worked so very hard on last year. And I think the interest here is ensuring that we have a vehicle available to consider this matter going forward, even as these same issues are being considered in other committees. So at this point in time, I'll just open it up. Are there any questions about the substitute to House Bill 43 as presented here? Okay, I see none. So at this point in time, I'll accept a motion.
Move to pass.
All right, there's a motion to pass on HB 43 LC 338362S. Is there a second? Second. Motion and a second. All right, any amendments? Discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, House Bill 43 is on to rules. So that is it. If you would please check your agendas. We potentially may have an additional committee meeting, and if so, we'll do what we can to get notice out to everyone, but no other meetings have been scheduled at this point in time. Thank you. We're adjourned.